with my little introduction, because nobody's ever interested in what the moderator has to say anyway. So if people miss that, I think that's acceptable. So a very warm welcome to everyone who joins us this afternoon, or depending on where you are. For some people, it's in the morning, I understand. And so thanks for everyone who's joining us today. And also a warm welcome to our three panelists today, which are Agata Hauser, Wojciech Sadurski, and Mark Dawson. And it's really a pleasure and an honor to have you here with us. You know, sometimes you have events where only the third person you wanted or the fourth person who you ask says yes, but this is not the case here. Like, this is really our first choice of panelists. So we're very, very pleased with having you here. The event we are undertaking today is called Poland's Constitutional Crisis from the perspective of EU and human rights law. And my name is Pierre Thielberger. I'm a professor of German public law and public international law at the Ruhr University of Bochum. Before we start, I'd like to thank the organizations who are organizing this event, which is the Institute for the International Law of Peace and Armed Conflict in Bochum, IFAV. On the one hand, the Center for International Affairs from the Law Faculty of Bochum, then the European Society of International Law, in particular, the Interest Group on Human Rights, and also the Völkerrechtsblog, who is one of the biggest blogs in the field of international law, who's live streaming our event today. Thanks to all of these organizations. Now, before I'd introduce the panelists, which I will do in just a second, I want to abuse at least my position as moderator to give you at least 2 minutes or so of an introduction so that we all have a good starting point, because I assume that our three speakers presuppose some knowledge that most of you might have, but not everyone might maybe have. So law and justice, that is the literal translation of the name of Poland's governing party, PiS. And I will not be trying to pronounce that in Polish. I leave that to Agata and Wojciech later on. But it is a bit ironic, given that a lot of observers would probably say since PiS took power in Poland, there's kind of a law and justice crisis in Poland. And specifically, this relates to the judiciary, which the PiS has been reforming, as they are calling it. And some people say this has literally triggered a full-blown rule of law crisis in Poland. And certainly these effects are not only on Polish law anymore, but have much broader implications for other states, and in particular for the European Union and for the Council of Europe. Now, PiS is really an interesting political animal, if you like. Agata and Wojciech can certainly say more about it, because it's quite a young party, founded only in 2001, but has had remarkable successes since then, was first in government in 2005 until 2007, and since 2015 is really the governing party in Poland, so the strong party. And since 2015, they really, this party has really shown that they have a new take on law and justice. So famously, as most of you will know, they appointed 5 new judges to the Constitutional Court. And they also refused to accept some of the previously appointed judges. So those of you who follow American politics might see some parallels here. Also some of the existing judges were sent into early retirement, and all of this created a lot of resistance. This is accompanied, of course, we're talking about human rights here in this, we're talking not mainly about the judiciary, about other developments, so new laws on abortion, new laws in the field of LGBTIQ community. This kind of went hand in hand. And of course, the EU has noticed that and has commented on that from the very beginning. But the big dilemma for the EU, of course, is a bit what to do. The influence that they have is quite limited. I think Mark will probably talk about this a bit more. On the one hand, you have the Article 7 TEU procedure, but that presupposes in unanimity. And if you think about some other member states, for instance, Hungary, you can see how far that will bring you. And then, of course, there's also the option for the European Commission of an infringement procedure before the Court of Justice of the EU. And we have seen that happening, but only with very limited success. I don't say too much on this because I know Mark will say about this. Now, the triggering for this event is something that happened last year, because the Polish response to all of this or maybe it isn't a response, I'm interested to hear what our speakers have to say about that, came last year with two decisions. They came with a bang, I would like to say. Yeah, so really surprising and forceful decisions. One in October, where the Constitutional Tribunal found that Article 1 and 19 of the TEU were incompatible with the Polish constitution, which in effect is essentially the abolition of the primacy of EU law. And what is very hurtful, if I may say, from a German perspective, is that in this decision, they relied very heavily also on the German Constitutional Court in their finding on the European Central Bank. Whether that was fair play or not, we'll certainly hear later from Mark, I'm sure. And then the other equally shocking, I will say, judgment came in November last year when the Constitutional Tribunal said that also part of the ECHR, namely Article 6, were partly incompatible with the Polish constitution, so the right to fair trial. So these decisions are really the trigger of this event, and that's what we also want to focus on a bit. We have decided to have three different perspectives on this, which is, of course, because of the three excellent speakers we have today. So Wojciech will focus a bit on the Polish public law perspective, Mark will focus a bit on the EU law perspective, and Agata will focus a bit on the European Convention on Human Rights perspective. Now, that brings me to the first speaker that I'll introduce, and that's Wojciech. Wojciech Sadurski is certainly someone probably who doesn't need introduction. That's why I will also be very brief. He is a professor of jurisprudence at the University of Sydney. At the moment, he's in New York. So for him, it's early morning. So we thank you very much that you join us. He's also a professor at the Center for Europe in the University of Warsaw. He was professor and also head of department at the European University and Institute in Florence from the time that I knew him. And his research is really focusing on legal theory, philosophy of law, comparative constitutionalism, but also constitutionalism in Central and Eastern Europe. Now, one thing I should also say about Wojciech, which probably you know, is that he's quite has gained in this whole debate quite a lot of attention because he was sued by the Polish governing party and the Poland public broadcaster for defamation, as it was called, mainly over some tweets in which he, let's say, very directly and unfilteredly criticized the government, and in particular also over controversy over the mayor of Gdansk, Paweł Adamowicz, who, as you know, was assassinated in 2019. So Wojciech is also very personally affected by this crisis, which we call a constitutional crisis. And with that, I would give you the word, Wojciech.
Great, thank you very much, Pierre. And it's great to see you, Agata and Mark, with whom I'm sharing this panel. Now, I would like to focus on in my very short introduction of about 10 minutes. I'll just turn the stopwatch on to be sure that I'm within the limits granted to me. On the judgment which you had mentioned, one of the two judgments which you had mentioned, Pierre, and that is the judgment of 7th October concerning relationship between Polish law and the EU law. And this judgment really should be read in connection with an earlier judgment of 14th July, which also basically attempted to do exactly the same thing, that is to quote unquote invalidate some articles of the EU treaty, and also in the case of July judgment of the Treaty of Functioning of the European Union under Polish constitution. Now, I should say that these are really not judgments because the Constitutional Tribunal was improperly composed. The panel was inappropriate. It contained in the judgment of July one improperly appointed judge, and in the full panel in October, 3 judges. So we shouldn't really refer to it with a technical concept of judgment. I prefer to talk about decision or maybe ruling, and if judgment, to put it in inverted marks. So inverted commas, rather. So these decisions and the July decision sort of prefigured the October decision. can be seen as really encapsulating almost everything that is wrong and troublesome in current Polish constitutionalism. So in a sense, I'll be highlighting these judgments, but in particular the last judgment, the October judgment, not in its own sake, so to yes, indeed, judgment, ruling, decision, not because it is so interesting for its own sake, but rather because it really is a good prism through which to look at all the democratic backsliding and especially demolition of the rule of law in Poland that the Law and Justice has been operating since 2015, since its double victory, first in presidential and then in parliamentary election. So the judgment, the decision of 7th October basically said that several articles, not just Article, I think you mentioned 2 and 19, but also Article 4 and Article 1 are unconstitutional in Poland, are inconsistent with Polish constitution insofar as three horrible things happened under these articles. First is that European Union institutions operate ultra vires beyond their legal competences. Second, that Polish constitution no longer is a supreme law in Poland. And third, that Poland no longer can operate as a democratic and sovereign state. So insofar, not if it happens, insofar as it happens. So we don't have a conditional or hypothetical statement. These things, three things happen. The Constitutional Tribunal deplores, of course, these developments and says that because these three things happen, insofar as they are allowed by Article 1, 2, 4, and 19, Section 1, these articles must be seen as incompatible with Polish constitution. And in particular, Article 19, Section 1, insofar as it may be seen as a basis for Polish judges to evaluate the appointment or propriety of appointment of other judges to their judicial positions. Now, let us just for a second, really for a second, try to pretend that it's a real judgment, and let's try to take it seriously, which of course is somewhat grotesque because even the way I had summarized it, and I tried not to distort it, such as how grotesque this ruling is. And by the way, we don't have yet an official and written rationale. We have reasons which were provided orally by Judge Rapporteur, and we have also a very comprehensive press release on the official website of Constitutional Tribunal. So even though obviously it doesn't have a legal form, nevertheless, as far as the habits of this Constitutional Tribunal are concerned, it will be largely repeated even when the reasons are released, and it may take a long time. So these are the grounds. So let's take it serious. How to understand? And I suggest that there are only three ways of understanding the judgment from the legal point of view and from the point of view of sorting out how does Constitutional Tribunal position Polish law, especially Polish constitutional law, vis-a-vis EU law, something to which I understand Mark will return. So first understanding is that it is a typical interpretation conforme type of judgment. That is that it's interpretive decision, that it says that under some interpretations, these articles are invalid, so the court mandates a proper interpretation of these articles. For example, interpretation under which a judge cannot assess validity of appointment of another judge. Now, on its face, such understanding of this decision doesn't make legal sense because there's only one court in Europe which has competence of final and authoritative interpretation of EU law, and happens not to be the Polish Constitutional Tribunal. Okay, so, and in any event, on its face, if you read the operative statement, because we don't have the reasons, but we have the operative parts of the judgment, this is not what Constitutional Tribunal says. It doesn't say it's an interpretive judgment. It's a judgment about the scope of this article. So this cannot be the way in which it is understood. The second understanding may be that this is a judgment which only means to invalidate the applicability of some judgments of the European Court of Justice or Court of Justice of European Union. In particular, the judgment which triggered the decision of Constitutional Tribunal, and that was the judgment of 2nd March 2021 of the Court of Justice, in which Court of Justice basically said that the appointments by the President of Poland on the advice or on recommendation of National Council of Judiciary of judges to the Supreme Court was incompatible with the principles adopted in Europe because there was no remedy against these recommendations, basically. So many judges appointed to Supreme Court were appointed in the procedure which is not recognizable in Europe as conform with the rule of law. Okay, so we may see this judgment or this decision of Polish Constitutional Tribunal as basically outlawing or invalidating, striking down, if you like, in Poland of the judgment of the Court of Justice of European. Now, again, this makes absolutely no legal sense, not just under EU law, but also under Polish constitutional law, because Constitution enumerates in an exhaustive way what can be the proper objects of scrutiny of Constitutional Tribunal, and judgments are not part of that. Okay, so the simply Polish Constitutional Tribunal has no such power. It acts expressly and explicitly ultra vires when it wants to overrule a judgment of any other court, whether it's a national court or a European court. So the third and the only probably legally prima facie valid way of reading this article, this judgment, is that Polish Constitutional Tribunal has indeed invalidated some articles, some norms of EU law, not interpretation, not judgment, but of EU treaty and earlier of Treaty of Functioning of the European Union insofar as it allows for interim measures. And that's the most serious, of course, issue, because here we face directly the question of primacy of EU law and of equal applicability of treaties in member states. But from the point of view of Polish constitutional law, it also is completely invalid, because under Polish case law and under the leading judgments, including a judgment referred to in the reasons for this last decision at the time of accession, Polish Constitutional Tribunal very clearly and wisely stated that the tribunal doesn't have the power of scrutinizing European treaties. It has the power to scrutinize treaty of accession treaty, and it has found it compatible with Polish constitution. So in this way, it has prevented future Constitutional Tribunal panels from directly assessing validity of EU treaty. And under EU law, of course, that's the only permissible conduct. So we have these three possible readings. None of them really is legally, even initially, even prima facie legitimate. So we have a puzzle, you know. I mean, I don't have too much faith in the legal wisdom of members of Polish Constitutional Tribunal, but they are educated lawyers, you know, and they must know that what they have handed down is a total and utter nonsense from the beginning to the end. Why did they do? And there is only one explanation, which is pretty obvious, pretty banal. The whole purpose, the whole exercise is not legal but political. And the political aim of this so-called judgment and of prior decision of July is to basically exempt legal transformation of judiciary in Poland from any European oversight. In this case, from an oversight by EU bodies. In the case of both November judgment and the judgment which we are expecting any day now, on which I suppose Agata will be talking, and that is oversight from the European Court of Human Rights. And once we see it this way, it's a way of basically providing safety zone for quote unquote legal reforms of the judiciary. It all starts making sense. So that is why I started by saying that these judgments encapsulate everything that is wrong about Polish system of justice as reformed or deformed perhaps by the government of peace since 2015, and of which three most scandalous or outrageous aspects which undermine judicial independence are, first, the massive action of court packing, of replacing old judges by new ones who are completely, trusted by the party. B, of personnel control of the top administration of the courts, especially court presidents and vice presidents with their immense power of case assignment. And three, the all-pervasive disciplinary action, which is like a cancer on the body of Polish judiciary, and which basically renders every judge accountable to the minister for the judgments, not for extrajudicial actions, for the judgment and other judicial decisions that they make. So once we see it in this way, Polish government wants to protect its changes to the judiciary, which are completely incompatible with even the most minimalistic understanding of the rule of law, then this strange, shocking, grotesque decision start making sense. But now, what are its true legal effects? We already know that the Commission in December, I think on the 22nd December, announced its infringement action against those two judgments, wisely, I think. And I guess we'll come back to this conversation both in Mark's presentation and in the discussion that will follow. Thank you.
Thank you, Wojciech, very much for these three interpretations of the judgments that hadn't even so much crossed my mind. I was jumping very easily to the third interpretation of yours. So thank you very much also for the insights you gave us there. And without further ado, I would give the word to Mark Dawson, who is our second speaker. He is a professor at the Hertie School for European Law and Governance, the Hertie School in Berlin. Has been before an assistant professor at Maastricht University, and his research focuses mainly, I would say, on two things. On the one hand, fiscal governance, if you like. So he certainly also has a lot of insight on the judgment that the Polish Constitutional Tribunal quoted, the judgment, or the German Constitutional Court's judgment on the European Central Bank. And he also has written recently a book with Cambridge on European fundamental rights. So his second research focus is human rights in Europe. And with that, I would give the word to Mark.
Okay, thank you very much, Pierre. And thank you to Pierre and to Lisa and the others at the FFL who have organized this. So I'm going to talk about the only thing related to this topic that I know something about, which is really the EU law perspective on the Polish constitutional crisis. There was a time when sort of rule of law and human rights issues were quite peripheral to my field of European law. This was kind of a subfield within the field of European law. But I think if you look at the discipline today, this issue has kind of become the central issue of European law, sort of the debate within which the most important judgments and developments in European law are happening. And if you look at, for example, Twitter, it's really the focus of discussions on EU law. So I want to say a few words about sort of how that became the case. How did the EU become such a central actor in the rule of law debate and the Polish debates? And also sort of how useful is the EU's oversight functions, as Wojciech mentioned, in tackling rule of law backsliding. Now, if you look to the past, I think the EU has tended to engage with rule of law and democratic backsliding in sort of different waves of activity. And those waves sort of began in the late 90s and the 2000s with a wave of essentially not doing very much on this topic, or presuming that member states complied with rule of law values. So that was the idea behind the original Article 7 procedure that Pierre mentioned, that was inserted into the treaty at the turn of the century, which is that we should assume basically that all EU states, once they fulfilled the accession criteria, if they're new, member states comply with the rule of law. And in the worst case, we might have one bad apple, like we had with Austria during that period, who the rest can punish if they have to. Now, the election of the Orban government in 2010 in Hungary, followed by a rule of law crisis in Romania 2 years later, really sort of ended this presumption. And what that started was that in the 2010s, and I think we're seeing sort of the end of that period now, you had the development of a wave of what you might call indirect intervention to tackle rule of law backsliding. And it was indirect for the reason that Pierre mentioned before, which is that the one direct mechanism, the Article 7 mechanism, was proven during this period to be effectively useless because of its unanimity requirement. At the same time, legal mechanisms that could be used, like the EU Charter of Fundamental Rights, they could only be used to tackle rule of law backsliding if the Commission could show that a breach of EU values was within the scope of the Charter, and therefore that there was some piece of EU legislation or some cross-border issue that brought a violation of the rule of law within the scope of the EU Charter. So you might call this something like the Al Capone era of rule of law intervention. You might remember the famous Chicago mobster Al Capone. You know, he wasn't brought down for murdering his enemies or criminal syndicates. He was brought down for tax evasion. The EU also sort of went through a phase like this. You know, firing judges wasn't primarily a problem of judicial independence. It was a problem of age discrimination. Closing critical radio stations was a problem of freedom of establishment. So you do something about the rule of law, but by pretending to do something else that has a firmer legal basis in the treaties. This era ended decisively, I think, and this is really where the crux of the current conflict between the Polish government and the Polish judiciary and the EU starts, with a very important judgment that occurred in 2018, February 2018, which actually had nothing to do with the rule of law at all, but which was about the Eurozone crisis, or the aftermath of the Eurozone crisis, which was the Portuguese judge's case, which gave the Court of Justice an opportunity to take an article of the treaty that was basically dormant up until that point, and which is the focus of the judgment that Wojciech has talked about, which is Article 19.1 of the treaty, and give it a totally new meaning. So if you look at the text of Article 19.1, its literal meaning is rather clear. It's about protecting the independence of the European Court of Justice and ensuring that other courts give proper effect to the judgments of the European Court of Justice. In that sense, it's not apparent from the text or apparent from other jurisprudence prior to this point that this provision was intended explicitly to say something about the independence of national judiciaries. In Portuguese judges, however, the Court of Justice argues exactly that. It says that giving full effect to EU law requires assurances that the national courts that actually apply EU law are sufficiently independent themselves. So having established this standard, the Court of Justice has essentially been using it over the course of the last 3 years extensively to question different acts of the Polish government, putting pressure on the Polish judiciary, and one of which is mentioned by Wojciech, the appointment process of judges, but also other acts such as the practices of the disciplinary chamber of the Polish highest courts. So in that sense, we're past the indirect stage, we're in the direct stage, where the Court of Justice is using Article 19.1 to question different acts of the Polish government, putting pressure on the Polish judiciary, and the Commission is much more actively supporting this endeavour by raising infringement actions in order to bring these cases before the Court of Justice. Now, what the Court of Justice is doing here, arguably, is something that is always done in the history of European integration, which is that when it's faced with political paralysis, when you have an inability of governments to do something about a given transnational problem, here the problem of disciplining a state with rule of law erosion, it has decided to step in itself and police the organization of national judiciaries. So you're essentially doing through law what really should be done through politics or through political negotiation. So something really radical has happened since 2018 in the way this provision has been applied. At the same time, we also have some significant changes at the political level. So after a lot of dithering, the EU passed this time last year a conditionality regulation linking access to the EU budget to compliance with rule of law standards. And the Commission seems poised right now to restrict Polish access to the Next Generation EU Fund, which is a gigantic pot of money, as a result of non-compliance with rule of law standards. So the stakes have been massively upped. We've gone from a relatively powerful mechanism that was practically useless, which is Article 7, to a less powerful mechanism, the conditionality regulation, but one that can much more easily be triggered. The question, of course, is where did we go from here? So the Polish government has referred the conditionality mechanism not just to the Court of Justice, where one would expect it to survive judicial scrutiny, but also to its own constitutional court. And of course, the judgment that Wojciech has extensively discussed, and actually the rationale and spin which Wojciech put on this judgment suggests that it's quite likely that the Poland's highest court will use this sort of manufactured powers that it's given to itself to declare the conditionality regulation to be ultra vires and to be beyond the powers of the EU. Now, I think there are different ways of looking at that step. One is, well, why should we care what this kangaroo court is doing, right? This court is not properly composed, and this court is acting with the boundaries of accepted European constitutional law, and therefore we should not pay or take too seriously the judgments that it issues. Another way of looking at this, though, is to say that some of the classical patterns of European law, including what I've discussed before, which is the idea of integration through law, using law to do what politics won't, is really reaching its limits in this episode. So this radical pattern of integration through law, according to its famous architects, the people who prophesized it, people like Joe Weiler, it worked in the past for two main reasons. The first reason it worked is because the stakes were low. So big breakthroughs by the Court of Justice, the establishment of doctrines like direct effect and supremacy and Van Gent and Costa VNL were made in cases where the cost of the member states were quite low and where the public generally had no clue that judgments were even being rendered. So there was a kind of permissive consensus. There wasn't a high degree of politicization surrounding the judgments in question. The second reason, of course, that integration through law could work was that domestic institutions were willing to play ball. Even if governments didn't like supremacy and direct effect, this is the famous Joe Weiler thesis, national courts saw advantages in those doctrines, and so they gradually incorporated provisions of EU law into national law. The danger, of course, is that this time these conditions decisively do not apply. So the EU, of course, will surely, and the Court of Justice will surely, as a result of these infringement actions that Wojciech mentions, insist upon the primacy of EU law. But what can we do if a member state in all sorts of judicial institutions just do not obey these rulings? So there's a certain, I think, triumphalism about the court's rule of law jurisprudence. You know, the court has finally done something. It's quite hard to find any EU law scholar who's really critical of these cases. There's a kind of a broad consensus behind them. But it's also perhaps the most dangerous thing the Court of Justice has ever done. You know, in essence, the Court of Justice is in danger of showing that the emperor has no clothes. So what can it do if Poland, its Constitutional Tribunal, its government simply accept the costs of non-compliance? So we're in a very difficult place from an EU law perspective. For this reason, and I'll finish on this because I know I'm going over time, EU law scholarship is turned into a kind of futurology of late. So lots of people are already imagining, how are we going to deal with this impasse that's clearly coming our way? And how can we come up with sort of out-of-the-box proposals to deal with it? So some people have argued, for example, that the judgment that Wojciech mentions itself constituted a de facto exit from the Union, or could be interpreted as a decision to trigger the procedure for withdrawal, the Article 50 procedure. Others have said we need something like an expulsion mechanism. Essentially, all the existing member states should leave the EU. They should leave Poland and Hungary behind, and they should create a union of their own without sort of the bad members. Now, I'm personally quite skeptical about, I think these are ingenious ideas, but I'm quite skeptical about both of them. And maybe I'll just finish by saying why. So the Whiteman judgment of the court, so the famous judgment of the court on the Article 50 procedure and Brexit, makes quite clear that Article 50 has to be explicitly triggered. There's actually something quite contradictory here in the logic of those saying that the K321 decision constituted the triggering of Article 50. Because how can you say at the same time, both that this tribunal is illegitimate and that this is the body with the legal authority for Poland to leave the European Union, that it has the constitutional authority to trigger this massive constitutional change in terms of Poland's relationship with the European Union? I also doubt in terms of the second option that the member states would envisage the massive upheaval involved in their withdrawal from the EU's entire institutional framework, at least while elections loom in both Hungary and Poland, where the opposition has a chance of doing this work itself, i.e. of coordinating so that the population itself can eject autocratic governments without the EU having to do this work. So there's no doubt that we need sort of imagination to solve this crisis. I just have a few question marks about some of these proposals, but I'm really looking forward to hearing what others think about them during the Q&A, and I think I'll stop there. Thanks very much.
Thank you very much, Mark, also for staying so great in time, as Wojciech did as well. And I will now stay within Europe, but move to a different institution, to the Council of Europe and the European Court of Human Rights, to be more precisely. So our last speaker is Agatha Hauser. It's a great pleasure to have you here as well, Agatha. Your research, or Agatha's research, focuses on judicial protection of individuals by the Court of Justice of the EU and the European Court of Human Rights, which is what she will be talking about today. You have published on the Venice Commission on electoral law, so quite a broad expert there. You are a lecturer also at the European Inter-University Center for Human Rights and Democratization in Venice, where I'm also teaching. We have never met, unfortunately, but hopefully one day we will, and sit at the Lido together. I'm looking forward to that. And at the moment, you are a visiting professor, a DAAD visiting professor at Ruhr University Bochum. We agreed that out of your broad expertise, I think you could have also spoken about many aspects that Wojciech and Mark have already covered. We agreed that you would focus mainly on the European Court of Human Rights implications, so on the second judgment that I mentioned in my introduction. And we are very much looking forward to hearing from you, Agatha.
Thank you very much, Pierre. I'm very happy that Wojciech and Mark focused on the EU, so I can present the Council of Europe system, which is interesting for me because the issue at hand is the protection of human rights. And I want to discuss the case of November 2021, not only in the context of the judicial reforms in Poland, but in the broader context. What may happen for individuals, for duty bearers, and for rights holders in Poland with regards to other issues than just the right to a fair trial. So, as Wojciech already mentioned, in November 2021, Polish Constitutional Court has declared that Article 6 of the European Convention on Human Rights, so the right to a fair trial, is partly unconstitutional. Now, I want to read the actual judgment, if I may. So, firstly, the court has said, to the extent that the term court includes the Constitutional Tribunal, and secondly, insofar as it confers competence to the European Court of Human Rights to review the legality of the election of judges to the Constitutional Tribunal, Article 6, Para 1 of the European Convention is unconstitutional. So this is a very striking decision, which judicial body states we are not a court of law. This was quite a surprise for people who have been studying Polish constitutional law, because already in the past we have had judgments in which the Constitutional Court before 2015 has actually applied Article 6 to the Constitutional Court, and was a very famous case in 2015 in which the court said the new regulation would violate on the Constitutional Court would violate inter alia Article 6. So why the sudden change? Why suddenly last year the Constitutional Court decided to invalidate partly one of the main provisions of the European Convention of Human Rights? Well, the vast majority of the doctrine links this judgment to the very famous zero flaw case decided by the European Court of Human Rights. Now, I want to explain that this is not my personal view, but it is shared by the vast majority of Polish scholars. And I, as I've promised to Pierre, I want to indicate that I do have a family connection to that case. I would say one of the judges elected in 2015 is my father. So I just want to make clear here that I'm not speaking as my father's daughter and representing myself and the opinion of the majority of my colleagues. So the zero flaw case built on a very recent case concerning Iceland. That's the Grand Chamber judgment in the Astrason case. So in this case, the European Court of Human Rights decided that the form of appointment of a judge might influence the impartiality and independence of the court itself. Now, the judgment of the Polish Constitutional Court, in a way, suggests that the Icelandic case was given ultra vires. So the European Court of Human Rights has suddenly changed the rules. This is not what we have agreed on. Now, that is in itself debatable. Well, it is true that in the Icelandic case, the European Court of Human Rights went further than before. There were already cases before the Icelandic one, especially in the case concerning Bulgaria, in which the European Court of Human Rights has said that one of the standards they have to verify when hearing cases concerning Article 6 is precisely the method of appointment. So the case of Astrason just in a way explained in more detail what's already clear to everyone. The notion of a court under Article 6 is an autonomous concept under the convention. So it doesn't matter at the level of the Council of Europe how a body is classified in the national order. It doesn't matter if it's an administrative body, a judicial body, or any other type of body. What is important for the European Court of Human Rights is whether or not the body in question exercises a judicial function. And in that case, they have decided, in the zero flaw case, they have decided, yes, in situations regarding, in particular, constitutional complaints, so cases brought by individuals, the Polish tribunal exercises judicial function. Now, as Wojciech has said, under Polish constitution, it is impossible to invalidate an individual decision, to challenge a judgment, an administrative decision. That's why it was impossible to, in a way, transfer that judgment to the court. The only option for the governing party was to challenge the actual wording, the actual provision of the European Convention of Human Rights, so the basis of the judgment of the European Court of Human Rights. Now, I was very much surprised, or being an internal optimist, I was very much surprised that no one even really considered using the appeal system built into the European Convention of Human Rights. As you all probably know, it is possible under the European Convention of Human Rights to go from, let's say, negative judgment of the chamber to the grant chamber. In this case, and in many others, the Polish government decided not to do that. In one case, they actually withdrew the referral from the grant chamber and decided to deal with the issue at the national level. Now, I think what is interesting about the Council of Europe system is that Poland is not the first state who is challenging final decisions of the European Court of Human Rights. For many years, we have been dealing with the situation of Russia, which also uses the same idea. Final judgment of the European Court of Human Rights is then transferred to the national court, and then the court verifies whether or not the judgment is in compliance with the Russian law. So we are not the only problem child in this context, but we are definitely not in a good company. Why is this potentially dangerous for all human rights in Poland? Because if we accept such an approach, there's a decision we disagree with, we are not going to challenge it before the European Court of Human Rights. We are going to render it to the Polish Judiciary, let's say, the Constitutional Court. Now, Pierre, in his introduction, mentioned two very important issues related to the protection of human rights in Poland. The first one is access to abortion, and the second one, the rights of the LGBTQIA+ community. Now, can you imagine a situation in which, let's say, someone loses their job on the basis of their sexual orientation, or a woman is denied access to abortion? They take a case to the European Court of Human Rights and they win. And that gives them absolutely nothing. It's that the government, let's say, challenges Article 8, so right to private and family life. It would be theoretically possible to use Article 8 of the Statute of the Council of Europe and either suspend or expel a state from the organization. So it's a similar situation to the one we have within the EU. But the problem is, and this is the last thing I want to say, that the Council of Europe has once in the 60s tried to use Article 8 in a very famous Greek case. I don't know if you've heard this story. After the coup d'etat, when the black colonels took over power in Greece, the Council of Europe triggered its procedure under Article 8. When that decision was transmitted to the new Greek government, the government simply informed the Council of Europe that they are actually withdrawing from the organization. Non-democratic governments do not enjoy international control mechanisms. So if that happens, I'm very much afraid that countries like Poland, like Russia, maybe others, would be very happy to leave the Council of Europe because there will be no financial repercussions. We do not get any money from the Council of Europe. And secondly, if we leave the Council of Europe, our citizens will no longer be able to bring their cases before the European Court of Human Rights. Thank you very much.
Thank you very much, Agatha. I would like to thank all of you. I would like to explain what we're going to do now. I know there's many people here. There's still more than 60 people here, I think. So it's really on 59 now, sorry. So I'm sure there's many questions in the room. I think some of the presentations were also a bit provocative, maybe in some ways, I would say, which is very good, which I appreciate a lot. So there's two ways. You can either ask a question via the chat function or the questions and answer session. Or which we actually prefer is if you raise your hand, we will see this too. I was told I will see it. I don't see it at the moment, but maybe there is no question yet. And then we could unlock your camera and your microphone for your question, which I think would be nice if we see you. So I think at the moment there is no question. I don't know whether I can see. I can see them now. With that, I will maybe ask my first question, and that is actually more whether any of you would like to react to each other. I mean, for instance, Wojciech, would you like to react to Agata? Because I know you're also quite an expert on some of the things she talked about. And
well, if there are no questions,
I'm sure there will be. It's just the first question is always, people are always shy.
Okay, so let me just perhaps make 2 points really triggered by Mark's presentation. So one is about article, and sorry, both are sort of like pedantic in a legal sense, but I think they raise some important issues. The first is Mark's statement that Article 19 has undergone some important transformation in the hands of Court of Justice, perhaps contrary or at least not anticipated by the founders. And that is because the Article 19, if I understood you, Mark, correctly, was meant to focus mainly on the Court of Justice, while in the Portuguese judges' case, it was somehow expanded also upon national member states. Well, I'm not 100% sure that I agree, because Article 19.1 has 2 sentences, rather 2 small paragraphs. One is indeed about Court of Justice, but the crucial and the most, in a sense, dramatic in the recent developments is the statement that applies to member states, and that provides that member states shall provide remedies sufficient to ensure effective legal protection in the fields covered by union law. So it is this effective legal protection which became a bone of contention in both Polish decisions, because this effective legal protection, which in some literature is then understood as effective judicial protection, is something that really matters for scrutiny of transformations or so-called reforms of the judiciary. So regardless of the intentions, and one knows that in Europe, the original intentions play much lesser role in interpretation of constitutional statutes than in the United States. Regardless of intentions, I think the textual interpretation of Article 19 doesn't require any overstretch to apply it in a way in which Court of Justice did it. And the second very brief point is about Article 7. Now, I do not share your and many other of my colleagues' skepticism about Article 7 as allegedly completely hopeless and unsuccessful, and that it is somehow a total non-starter when it comes to the oversight. First of all, we should be talking about Article 7, Section 1, which doesn't require unanimity, and which is now, in a sense, developing both vis-a-vis Poland and Hungary. And second is that even if it doesn't lead to its ultimate end, that is to this statement or declaration about the risk of breach, etc., it has very important indirect action. It's being referred to in the reasons for infringement actions by the Commission. It is being referred to by national courts, for example, by the Irish court about the extradition, etc. So the fact that there is a procedure in itself, legally speaking, and therefore politically, is quite salient and important, I think. Okay, thank you.
Maybe I give Mark the chance to answer, and then I will ask a question too. And there's also, I think, some statements, at least in the chat now.
Yeah, and Wojciech, you're absolutely right. Of course, I was a bit quick in the way I described Article 19.1. I still would stick with the point in the sense that sort of, if you look at the history of the way that particular line of Article 19.1 you mentioned has been used, it has been used in a relatively restrictive way, right? So for example, it's been used and interpreted by the court as demanding some kind of equivalence in terms of the way national courts apply national remedies and versus e-remedies. So if they provide a particular remedy under national law, a similar remedy ought to apply under European law. That is sort of much less intrusive in the prerogatives of member states and the organizations of the national judiciaries than the interpretation that's now been given to it, which is actually about structural features of the national judiciary. So there's no doubt that there is a way of interpreting it as sort of bringing these elements in, especially if you tie this with the kind of effet utile doctrine in European law. But one also has to acknowledge that it's quite expansive, right? So, and I think it's expansive in particular in relation to the other member states, because it opens a whole line of judicial supervision tailored for the Polish case, which is that, there should be some kind of minimal standards in relation to judicial organization that actually has potentially quite wide-ranging knock-on effects in lots of other states. And on the Article 7, I also would take Wojciech's point. I think though one should look at this a little bit from the perspective of citizens. And I think the overriding impression they get is of a kind of paralysis, right? Of basic stories of Article 7 being triggered and the feeling that something is happening, and even institutions making something of this, that the European Parliament has acted, and then nothing, no sort of follow-up on that, and no real consequences for the state concerned. And of course, the dialogue mechanism that was introduced compounded that problem, because it essentially became a mechanism for obfuscation and for delay and not for any real consequences being brought. So I take your point about the expressive value of the procedure, but this, I think it's probably communicated to citizens as being about sanctions, and when those sanctions don't follow, that can lead to sort of fatigue and disappointment. I had one question, maybe I'll leave it hanging in the air. It's something often you sort of hear, and I wonder whether it's true, and it relates to Agata's presentation, which is the idea that domestically in Poland, we have a dramatic rule of law erosion, but that doesn't necessarily translate into a general fundamental rights erosion. The sort of the normal safeguards for more broader fundamental rights review by courts, that they persist and that they continue. And that there's still meaningful levels of fundamental rights review, even if there are acts against judicial independence. That these are some of the optimistic messages I've sometimes read, and I wonder whether that's true. But yeah, this is just something I leave hanging in the air.
And before I give the floor to the people who want to ask questions, I would also like to ask one question, and that is, if I understand you correctly, Agata and Mark, you've both very explicitly kind of spoken out about the possibility of excluding Poland either from the Council of Europe or the European Union, or even to understand the judgment, as Mark said, in a way that this would be the will of, that this is kind of, should be interpreted in this way, that this could be implicitly seen as triggering Article 15 or whatever. But the question is a bit by where is the limit to where is the limit when we should consider this? There must be a limit at some point where we say, I know what happens in the next election. We don't know what the next reforms will be of the judicial sector or other sectors. Where do we draw the line? Don't we, in the long run, really really hurt those institutions that are the Council of Europe and the European Union by not doing any of that? Agata or Mark, to you.
So if I may, I gave you the Greek example from 1960s, and precisely after the fall of the regime, the new Greek government reapplied to the Council of Europe. So basically, we have to wait for the new elections. That is, a good solution from the point of view of the European institutions. But on the other hand, as a human rights lawyer, I would be concerned about lack of international judicial review of the decisions still. So in the end, if we are expelled or we withdraw from, let's say, Council of Europe, individuals whose rights were violated have no way to challenge those decisions. Because obviously I'm focusing on the Council of Europe, but the same could be applied to the decisions of, I know, UN treaty bodies or any other international human rights bodies. So whereas Mark, I would agree that we still have wonderful judges, and they are doing their best to, in a way, safeguard individuals' rights, basic values like right to privacy, etc. There are sadly some decisions that are, let's say, questionable. And if we have some problems with both the Constitutional Court and now with certain chambers of the Supreme Court, then at some point that general approach to individuals' rights might change.
Mark, do you want to add something?
Yeah, I mean, I actually wanted to mention one other judgment of the Court of Justice, which is called Republica, which was also issued last year, which basically introduced this idea of non-retrogression, basically, and explicitly tied this to accession criteria. So the idea is sort of, once you've committed to a certain level of fundamental rights protection, rule of law protection within accession, you can't backtrack on this. And I thought it was quite interesting to bring up in light of Agata's presentation, because she mentioned the prospect of Poland, as an example, leaving the Council of Europe system. And I wonder whether that would be compatible actually with EU membership. All EU member states are Council of Europe members. That would be a very explicit example of retrogression. And maybe this might be the kind of step, that could potentially trigger discussions over expulsion. But there is no mechanism within the treaty that would allow for that. I mean, that's why I mentioned these sort of out-of-the-box proposals. They're out of the box because they require a lot of kind of constitutional and legal imagination. But if you look at kind of the formal provisions of the treaty, there's no ability of the others to expel. You can expel yourself. That's the way the system works. And so we're not quite there yet from a legal perspective.
Okay, I would give the floor now to Sylvia Uskov, who had a question. Sylvia, if I may call you Sylvia, we would now give you the floor. And if you want, you can also put your video on. That depends on you. At least you can if you want. I think you have the possibility. Can you hear us? Can you say something? You have to unmute yourself. There you are.
Hello.
Hi.
I'm Silvia Uskov. I'm an attorney from Romania. I'm attending this panel because we also have a problem with Romania lately, in the light of the Court of Luxembourg's judgment from 21st of December last year. We don't have a problem regarding the human rights because we have in our constitution written there that they are treated differently. Human rights, we apply the standards that are higher, no matter if they're in the Constitution or in the European Convention of Human Rights. So we don't have a problem like Poland has. But we have a problem regarding the application of the European law. So I'm starting to ask myself and yourself also, do you think this is Poland's constitutional crisis or an EU constitutional crisis? And the second question would be, do you think that a political remedy would be more appropriate than a judicial one, or the one that asks for an expulsion, like you said, from the Council of Europe or EU? Because, like I said, we have these questions raised in our country. The EU said that they could start an infringement procedure against Romania. We say that the constitution is our basis, and when we entered in the EU, we had the same constitution, so everybody knew what we were willing to give to the EU in terms of sovereign and the exercise of the competences of the EU. And that's why I'm saying that maybe we are facing now a reconstruction of the EU, and maybe that's why we have these issues that are treated both by the European Court of Human Rights, but also by the CJEU. Thank you.
Thank you. I imagine that many of you could answer this. I'm giving the word to Wojciech because I assume he really wants to answer this.
Yes. Well, thank you very much, Sylvia, if I may. You're absolutely right. This issue of reluctance by constitutional courts to take the primacy of EU law seriously is not just a matter of Poland. It's also a matter of Hungarian Constitutional Court, for example, in its cases about migrant quota, and of the Constitutional Court of Romania, of your country. And indeed, its judgment was absolutely outrageous. It in some ways is similar to the judgment or to the decision of Polish Constitutional Tribunal, because it also related to some disciplinary structures within the Romanian judiciary, although in a much more limited way. It also applied to special status of conditionality in Romania. And it used very, quote unquote, generously an idea of constitutional identity of Romania in order basically to escape European oversight. In addition, it contained a very dangerous idea that whatever Constitutional Court of Romania, whatever law or decree even, that is statute or sub-statutory law, Romanian Constitutional Court approves, then it immediately automatically becomes part of the constitution, that is, acquires constitutional standing, in which ways it may be seen as being above EU law. So we have this copycat or spillover, if you like, phenomenon, which is very dangerous. But so as a principle, yes, this becomes broader. However, I still insist the Polish constitutional crisis is incomparable with what's going on in Romania or in Hungary, because it is, well, Hungary is slightly different. I won't be going into it, because it's not part and part, because in Romania in particular, it's not part and parcel of an overall assault upon judicial independence. So yes, I agree, we have this problem, but I wouldn't call it EU constitutional crisis, because it would sort of like rhetorically lay the blame at the door of the European institutions. I think here the national constitutional court in Poland and in Hungary and Romania are the only ones to blame.
So more multiple constitutional crisis in Europe.
Sorry, I would just want to say something. Well, of course, but when a country wants to enter such alliance, right, like the Council of Europe or the EU, you check their constitution and you see how they will react when another court, then the Constitutional Court, will say something else. So I'm referring to Romania because I know our constitution. I don't know what's written in the Poland's constitution. And in Romania, like I said, we have the highest standard for human rights. So we're not like Poland's in Poland's situation, but for the EU, we say that the treaties and the EU law is situated right behind the constitution and right above our national laws. So, and also in the frame that our constitution is the one that permits to be EU member state. That's why the Constitutional Court, and I agree with it, the Romanian Constitutional Court in this matter, since I see that EU, in my opinion, is trying to have more competences than the state members agreed when they entered the EU. And I'm referring to all member states. They can all be in the same situation. And I don't know if France or Germany would agree, even if Germany was in somehow the same situation last year, I think, and they sent a letter to the European Commission saying that they will apply the EU law, and they will not say that their constitution is in the supremacy in front of the EU law.
We have
like
another question.
Okay, I want to thank you very much.
Okay, thank you, Sylvia. That's also a good way to come to our second question that was posted in the chat by Aaron Dumont. And I'll read it to you. As Professor Thielberger indicated at the beginning, there are voices in the discourse that see the Bundesverfassungsgericht judgment of last year as door opener for the Polish judgment. I think this is meant the judgment on the European Central Bank here. And do you think that the Bundesverfassungsgericht, so the Constitutional Court of Germany or other courts, should distance themselves from this misinterpretation of their own judgments in advance? Or is that not a responsibility of courts at all and should be clarified only by the public debate, for instance, media, which would then enhance the danger of danger by fake news? I don't know who wants to answer. Mark is quite an expert on that topic, of course, but I guess others could also answer.
Maybe I can say something on that. I mean, I think that's asking quite a lot for the German Constitutional Court to sort of anticipate how other courts might misuse its judgment. I mean, indeed, as Pierre, I think, pointed out in the introduction, indeed, this judgment of the German Constitutional Court, the PSPP judgment, has been extensively misused. And I say that because I think there's no relevant comparison between the two judgments that were discussed, the Romanian judgment and the Polish judgment, which Wojciech discussed, and the PSPP judgments, neither in kind of the quality of the reasoning, which is something that Wojciech has discussed. You know, to give one example, the PSPP judgment sort of extensively, which has been, by the way, of course, massively criticized by EU law scholars, it does extensively, nonetheless, engage with EU law and try to justify its deviations from central principles of EU law. So from a legal perspective, I think the comparison is not a useful one. But also in terms of kind of the overall challenge that the German Constitutional Court lays down, I mean, as Wojciech mentioned in the Polish case, you're challenging the very applicability of the treaties. You're challenging sort of core elements of European law, the very notion of what it means to be part of the legal order. What the German Constitutional Court was doing was challenging a specific program of a specific EU institution and declaring it ultra vires only to the extent that it breached a specific general principle of EU law, namely the proportionality principle. And even then, you know, 2 months later, it decided everything was fine. And so, you know, we should be clear that sort of the way that this judgment has been used by other constitutional courts is misuse. And analogously to what Agata and Wojciech has said, I think that misuse, the responsibility for that lies with those courts and not with Karlsruhe. And I'm really sounding like an adopted German here, so I'll stop there.
Okay, does someone want to add? No, so no responsibility.
If I can just add one word, I fully agree 100% with what Mark said about the mismatch between the German court's decision responding to Weiss' decision and what happened in Poland, and there was a good deal of hypocrisy in Polish Constitutional Tribunal trying to present its judgment as just the same as the other. But there was another interesting idea in the question raised, and that is, should Bundesverfassungsgericht now say something? Look, we are being misrepresented, and send a message. Of course, there is always a risk in such thing. On the other hand, perhaps, because this is basically not to courts to teach other courts what should be doing. On the other hand, there is an interesting idea by a very important legal scholar from Italy and a good friend of mine, Oreste Policino from Bocconi, who says, look, there are some constitutional courts within the EU, Bundesverfassungsgericht, Corte Costituzionale, Conseil Constitutionnel, which sort of de facto play a leading role in shaping relationship between national and EU law, and therefore they should acquire this more pedagogical role as masters. Now, I know that it sounds sort of patronizing and maybe even arrogant to some, but I personally wouldn't mind if judges of these courts, perhaps in their extrajudicial capacities, made these type of statements.
Well, that reminds me of something. So I have to, before I give the floor to some of the other questions, that reminds me of a debate that actually I had with some of my PhD students recently. And that is, where is actually the limit between what we do as academics and what you do as political activists? That's something that goes back to something that Jan Komarek has published and has been very much debated. I'm sure you are familiar with this debate, and that links in very nicely here. So, I mean, is this, I mean, what do you see as the responsibility of academics here to engage in this kind of public debate or not? I mean, is it not, I mean, the argument being made is that too often we kind of do that, yeah? And that we should kind of stick to being academics and being good lawyers, maybe in this case, and not engaging in this kind of public debate and have a very strict line between what we do and how we do it. So would that not maybe be overstepping the line here? Playing this back to Wojciech? Or to whoever wants to answer.
So if I may very briefly, I think that in times of crises, we do have obligation to the public. Normally, we do focus on our students, our PhD students, whatever, and we try to be rather restrictive, objective. But if something really bad happens, we have to explain why something is wrong. And I'll tell you why this is very important for me. My students are only 20 years old. They don't really remember a history of the Polish constitutional crisis because they were in school, they couldn't care less at that point, and now they simply don't understand. So when they ask me, so Agata, what is going on? Because there's this judgment of the Court of Justice and we don't understand. And I can explain that situation to my students, but if we try to be more active, we can potentially reach more people, some younger people who have to realize that we are talking about their basic human rights and they should be able to understand that this is important for them as citizens.
I just want to add that I don't even understand how one can be a public and constitutional lawyer and escape or avoid taking a public stand. But as someone who is exhibit number one in this wrongful activism in Jan Komarek's assault, maybe I shouldn't say anything more because I cannot be a judge in my own case.
I think very briefly, just to give the context, Jan's article was about sort of scientific freedom and examples of things that might fall on the line of being in, you know, a correct utilization of scientific freedom, and perhaps on the other line of not correctly utilizing this badge of scientific freedom. And I think there were some examples that were given that were probably very valid and very interesting, and examples that were not. And I think one of the example I'm referring to here is that as academics, of course, we're scientists, but we also are in a profession, right? And I think that profession involves some kind of solidarity to colleagues. So I think in that sense, if colleagues are targeted by governments in their scientific capacity, and if they're silenced by their government, we owe solidarity to our colleagues. And that, of course, that is an exercise of our academic freedom. So I think this, actually, I find the article really interesting and it's provoked a really interesting debate, but this specific example in which Wojciech was implicated, I would be very critical of what was written there.
We have a question by Joanne Lefort. You can put on your camera if you want, Joanne, as you like.
Yeah, sorry, it took a bit of time to settle things right. So just to give a bit of context of who I am, I'm Johan Lefort. I'm a former student at the Ruhr University of Bochum and now working for Professor Puttler, also at the Ruhr University of Bochum. And that's not really a question what I'm going to tell here, but rather a comment on what Silvia previously mentioned, namely, what if France was in the same situation? And I must say that 2021 was also the year in which France, in one of the high courts, administrative courts in France, decided to also make quite an earthquake judgment, namely French Data Network, in which it said, it reaffirmed the primacy of EU law, and at the same time, after less than a year after the PSPP judgment in Germany, decided to refuse any possibility in France to make an ultra-virus control in France. So that still shows that the French judges decided to react to those to the German way, and I think that somehow sensed the Polish ways or the Polish problems and decided to, on their side, still put some exceptions to the primacy of EU law still in that judgment, which we are still analyzing. It's quite recent, so we are still trying to understand it. But the French judges still try to reaffirm EU law, the primacy of EU law, and to say the Germans decided to do ultra-virus, decided to step in a bit, we won't do the same. So that still shows somehow that judges speak with each other through judgments, and that's, well, it may be a crisis in some countries or others, but also one main country decided to say, not really to us.
Great, thank you very much for this insight on the French case law. Is there anyone who wants to react to this? No, then we take it as a comment, as it was also announced. Thanks, Joanne, for this. If there are no other further questions, I would have final questions to all our participants. I think we've lost Agatha now. I don't know why that is. Hope she's coming back. There is one more question. Then I would allow that, and then I would have my final question. Agnieszka Kubal, could we get her in as a participant? Hello, Agnieszka. And we need to get Agatha back because she was somehow degraded to be a participant, she tells me.
Hi, I was wondering if you could hear me. Thank you very much for this fantastic panel. And I'm, yes, really grateful for the opportunity to listen. My question is to Agatha, and that's why I would really like to hear her view on that. She put, so my name is Agnieszka Kubal and I'm a lecturer in sociology at the School of Slavonic and European Studies at UCL. And I am not a lawyer, I'm a sociologist. So I'm very much interested in how people respond to those different crises, and including the rule of law crisis in Poland. I'm currently doing a project on how people mobilize human rights law in Eastern Europe and Russia. And Agata mentioned that the other country, except for Poland, that sort of has a rather thorny relationship with the European Court of Human Rights is Russia, because of its decision of the Constitutional Tribunal, which later became law, that sort of excluded Russia or gave Russian Constitutional Court a supervisory role over the judgments of the European Court of Human Rights. And yet, so it's now 5 years since this judgment has been implemented, and yet we can see how it has been implemented. it has been implemented very strategically. It has been implemented in Russia, particularly with cases that I would say are of particular political leaning or political importance, because the only cases that have been actually questioned by the Russian Constitutional Court are the Yukos case, which of course we know brought the biggest sort of non-pecuniary damage for Mr. Khodorkovsky, the Anchugov and Gladkov case, which again it's about prisoners' voting rights. And we know the UK itself has a problem with implementing judgments from prisoners about prisoners' voting rights, judgments against the UK. And then Konstantin Marking, which is again about gender equality in the army. So I was wondering if it's really fair to put Poland in the same camp as Russia, given that the decision of the Constitutional Tribunal is so blanket. It basically says there is a blanket ban, in other words, I mean, using vernacular language, a blanket ban on any cases that will reach the European Court of Human Rights that consider or concern the decisions of the Polish Constitutional Tribunal within Article 6, right to fair trial, which to me is setting the filter already of all the potential cases that can reach the European Court of Human Rights, rather than saying, okay, we will see what the judgments are and then apply our discretion as in the case of Russia. Because to me, that is quite big impediment, given that Polish citizens are among the top 5 citizens in terms of the numbers of cases submitted to the European Court of Human Rights, particularly. So they are quite, I would say, eager to mobilize the European Court of Human Rights law vis-a-vis the different abuses that the state abuses of power that the state might lead to. So apologies for this really long intervention, but I just really wanted to sketch the comparative context.
Yeah, I thought it was also a bit
much.
of a provocative comparison when I heard it. So thanks for bringing this up. And I'm sure Agata would like to answer.
Yes, thank you very much, Agnieszka. If I may, it was a very interesting comparison to the Russian case. And now, listen, it is very difficult to know what is going to happen in the future. As a human rights lawyer, I'm always worried about the first signs of trouble. So, you know, if in a way the door was already opened, we just have to be careful about what happens next. So this is all extremely theoretical now. I mean, from the point of view of the current situation, the only problem is to what extent individuals who want to bring a case to the European Court of Human Rights should firstly address the Constitutional Court. So should they bring individual cases to the Constitutional Court before they approach the European Court of Human Rights? Is the zero floor, if the zero floor case is not actually properly implemented in Poland. So the rest is theoretical, but we'll see what happens.
And not to misquote you, I mean, you did say we are not the only problem case, but we are not in good company. That was your words. So maybe that's fair.
I had used, yeah, and I'll briefly explain, because the Council of Europe took the strongest action against Russia after the annexation of the Crimea. So that was a different type of violation of rules. So that is the only reason for the use of words.
My last question is maybe a bit going against what I said before, because it merges a bit, you know, what I can ask you as an academic and what I can ask you politically. But that is your prediction of how this constitutional crisis will continue. Yeah. So what will happen following the next election, in the scenario how the elections might go, but what would it also mean? I mean, are things going to get worse, or have we got the worst behind us, even if there's no political change in the next election? What is your prediction for Poland? And I know I'm going against my own comment earlier, but that's okay. Konrad Adenauer said famously, what do I care about what I said yesterday? So I can say, what do I care about what I said half an hour ago? So Wojciech, you know Poland so well. I mean, what's your prediction? I mean, is it?
Well, my prediction is, okay, so the current government and the current party has about 3 more years to go. No, wait a minute. I think the next parliamentary election is 2023. Am I right, Agata? So it's really 1.5, say, year to go. The president has 1 more year because there is a 5 years term. And I cannot see any positive change before the elections. And I don't think there will be snap election. That would be suicide, political suicide by Kaczynski. Nothing will improve during this 1.5 years. They will be trying to spread their assault upon democratic principles now upon the freedom of media. They already tried, they failed, but they will certainly repeat. There will be several judgments coming up by the European Court of Justice, which definitely will be detrimental to the current ruling elite. And therefore, I believe that the only change, positive change, which may happen and which will happen, will be the next election if the current right-wing coalition loses this election, which is possible, which is not very highly likely because there isn't even playing field, but it is possible. It's much more possible than in Hungary, even though they now have this coalition anti-Orban. So, and of course, if the government, if some sort of liberal, centrist, left-wing coalition wins in Poland, it will all change, you know, and there will be, and many lawyers in Poland are now very seriously thinking about how to undo those terrible changes. However, if peace wins again, then it will be a road to Polexit. Mark is absolutely right. There is no way of having a tacit or implicit exit from the EU, and there is no expulsion procedure. Polish government will not, out of its own will, establish Article 50 because Poles are very pro-EU. So my formula is they don't want to withdraw Poland from the EU, but they want to withdraw EU from Poland. And that's what they will keep doing. How the EU institutions will respond to it, no one knows. Thank you.
Mark, I mean, you're not an expert on Poland per se, but what's your prediction for the relationship with the EU?
I mean, I think Wojciech is right that Poland will continue to lose before the Court of Justice. I think the Court of Justice is preparing for, you know, one more very decisive restatement of the primacy of EU law, which we'll see when it comments on this judgment. I think the big question is what the Commission does in relation to conditionality in the budget, right? The Commission has to hold firm on conditionality in the budget. You know, there is a history of the Commission sort of, in English, we'd say marching the troops to the top of the hill and marching them down again. And that would obviously send a rather bad message. But my feeling is that indeed conditionality will be applied, which will apply pressure, but indeed the only real solution is a political solution and a change of government, and we'll see whether that comes.
The last word goes to Agata, which I think is also appropriate because you're the only one who actually lives in Poland right now. So what is your prediction?
So it is very difficult to predict anything at this point. I mean, if we talk about the elections, we would have to factor in the financial crisis, which is just beginning here in Poland. That might have stronger influence on the people's opinions than constitutional crisis or anything like that. From the point of view of the Council of Europe, it is very interesting that already twice our list of candidates for the judges to the European Court of Human Rights were rejected. So I think, of course, the preparation of the list was problematic because for all the issues we've been discussing here, so lack of transparency, things like that. But I think that the fact that the list was rejected, or the committee suggested that the list is rejected, gives us a hint that the Council of Europe sees the problem and they want to put stronger political pressure to the extent it is possible within the Council of Europe without actually triggering Article 8.
Okay, thank you very much. We're already 6 minutes over time, so I would conclude here, but by first of all, thanking a few people again before I let you go. And before I thank the panelists, which is the obvious thank, I would also like to thank a few people behind the curtains because they never get any praise. So I would like to thank Elisa Cohen, who was helping with the technical side today, also Jan-Philipp Graf, both from Ruhr University Bochum, and also Maike Krakau from Völkerrechtsblog. Thank you very much for making this possible. It was really a great pleasure to have so many people here. I know everyone is a bit fatigued of Zoom meetings, but when we had more than 100 registrations, I thought, well, this is really something that is important for people. And I think we've had a really wonderful discussion, and that was only so because of our three fantastic speakers. Thank you very much, Agata Hauser, Mark Dawson, and Wojciech. It was really, really great with the three of you, and I hope I'll hear from you again soon. And thank you very much for being with us and making this possible. And I wish you all a wonderful evening, and all the best to you, and all stay healthy, of course, in these times. That's very important. All the best.
Thank you. Bye-bye.
Thank you very much.
Thanks again. There's so many thank yous and compliments to your contributions, by the way, in the chat, if you want to read them. I think we can also even still stay if you want for 1 minute. Thank you again. I think everyone's is leaving now, but yeah, thank you. It was really a pleasure. I hope to really see you soon. Agata and I had actually planned, because she was supposed to be in Bochum as well today, so we had planned to go for a drink tonight after the event, but that's not now possible because yeah, in the end, Agata couldn't come, and I am not even in Bochum right now myself. So yeah, but we'll hopefully do this through Agata, and I hope you are soon, Wojciech. Yeah, if you are in Berlin or in Germany anyway, let us know. Yeah, you're always very, very welcome here.
Thank you, and I will claim my drink then from you.
Oh yes, you can. Not only one.
Or we can get Wojciech to teach in Venice so he can join us on Lido for an Aperol Spritz.
Sempre, sempre con piacere.
But you know, Agata, the problem is I think your courses are scheduled very different times from mine. Is that possible? Because I'm always in Lido in November, December. It's not even nice.
I'm always complaining because Pierre is, you know, I could potentially go with him, but it's the time of the year when the entirety of Venice is covered in fog and it's, you know, raining, and
it's not a good time to go. I have to see about this. But the teaching in Venice is only in the winter term, right? So it's only in September, from September. You know better, Agata. You're more involved. September till December or January. So there is no way to teach in June there, right? Which would be nice, but
no. So we are rather lucky because I teach week 5, so that's pretty early in the program. So that's economic, social, culturalized, and that's mid-October, and it's normally absolutely lovely. But Pierre, there are those meetings of, you know, councils, commissions, committees, and things like that. So those are in September.
Yeah. Okay. Well, anyway, I have to say, Wojciech, I was recently saying to a friend of mine, I really want to go back to New York. I haven't been so long, so I'm really envious of you. Do you have some home there as well, or are you visiting someone? Because it doesn't look like a hotel room where you are.
No. I'm renting an apartment. I'm visiting at Rutgers University in New Jersey,
great.
which is very close.
Yeah. Okay, well, anyway, thank you so much. And it will be a pleasure. With your permission, we will also put it online on Völkerrechtsblog. It was recorded, so, but I think that's fine for everyone, or Agata as well. Yeah, okay, good. Then thank you very much again to everyone, and see you soon. Bye.
Thank you, Pierre, Mark, Agata.
thanks
See you
everyone.
next
Thank you,
time.
Wojciech.
Bye-bye.
Bye-bye. Thank you, Lisa.
Yeah, Lisa too.
And Lisa, many thanks to Lisa, yes.
You're welcome. It was great. Thank you.
Bye-bye.
Thank you. Bye-bye.